So, in this video, we will discuss what is exactly administrative discretion means and how it is defined by Dr. Smith in his Judicial Review of Administrative Actions show by Justice Cook in the Rooke case in 1598. So, Dr. Smith, in his Judicial Review of Administrative Action, defines it as to make a choice between alternative courses of action. And Justice Cook in Rooke versus Emperor case in 1598 said that it is to discern between falsity and truth, between right and wrong, and among various available alternatives, and not according to the will and the private affection, but in accordance with rule of reason and justice. So, almost administrative actions shall have the following course of action as we derived from these very two definitions as given by Dr. Smith and Justice Cook, that administrative course of action shall be appropriate, beneficial, and equitable, and it must be convenient, safe, sufficient, wholesome, and it must be deemed to be fit and efficient. And these actions of the administrative authorities under their administrative discretion shall follow the following requirements. And now we'll discuss how administrative discretion developed in different constitutions. So regarding American Constitution, we'll discuss certain leading cases like Overton Park versus Volpe in 1970, then Barlow versus Collins in 1970, also in Boreta Enterprises and Department of Alcoholic Beverage Control in 1970, also the leading case United States versus Professional Air Traffic Controllers Organization 1970. So also Section 10 of Administrative Procedure Act 1946. So in the very leading case Overton Park versus Volpo, the Secretary of Transportation, and Barlow versus Collins case in 1970, the Secretary of Agriculture were not followed the due process of law in their very administrative discretion. So the Section 10 of Administrative Procedure Code 1946 was not followed. So the very discretionary actions of the administration was held unlawful, arbitrary, capricious, or an abuse of that discretion and not in accordance with law. So, exception to Section 10 of the Administrative Procedure Act of 1946, that the absolute discretion was not subject to judicial review, was also held unconstitutional. And in England, or under English constitution system, as they have an unwritten constitution in the leading case, Fatfield versus Minister of Agriculture in 1968 and R versus Metropolitan Police Commissioner in 1968. It was laid down by the Queen's bench that the parameters of judicial control of administrative discretion is there. So the decision held that though the parliament is supreme and can confer any amount of discretion on the administrative authority, but the long arms of the court reaches out to administrative discretion to correct its abuse. And now we'll go to the French Constitution, where the administrative court or the council that are the highest and the supreme courts to decide every matter. So in France, the administrative courts exercise power of judicial review over administrative action in the administrative authorities when it abuses its discretionary power. And in the context of Indian Constitution, we'll discuss also certain leading cases such as State of Punjab versus Khemchand in 1952 and the Himatlal Shah versus Police Commissioner 1973 and Maneka Gandhi versus Union of India 1978 and R.R. Burma versus Union of India in 1980. So, in the first case, that is in State of Punjab versus Khemchand in 1952, in East Punjab Requisition of Movable Property Act 1947, the very requisition of truck by the district magistrate was held violative of Article 14 as there is no particular mention of public purpose in such requisition. And Himmat Lal Shah and Police Commissioner of 1973, the Rule 7 of Section 44 of Bombay Police Act 1951 was challenged and by where a public meeting on a public street was refused by the administration. So it was held violative of fundamental right as provided under Article 19 of the Constitution of India. And in the most important leading case, Maneka Gandhi versus Union of India in 1978, the apex court held that in case of misutilization of discretionary power, the arms of the court long enough to reach it. And in Rampur Distillery versus Company Law Board in 1969, the wide discretionary power under Section 326 of Companies Act 1956 was held invalid. And finally, in the important leading case, R.R. Burma versus Union of India 1980, Chief Justice P.N. Bhagavati held that discretionary power given to the government or quasi-governmental authorities must be hedged by policy standards, procedural safeguards, or guidelines, failing which the exercise of discretion and its delegation may be quashed by the courts. So, this was the position as it was upheld. The very question of the validity of administrative discretion, as we have discussed in the very context of American Constitution, the English constitutional system, the French Constitution, and also in Indian Constitution. So, in our next video, we will discuss regarding the very need of administrative discretion and which falls under very need or requirements of administrative discretion as regarding the very need of it due to modern welfare state and due to lack of time for legislation by the legislature and the very technical nature of legislation and the very flexibility of administrative discretion and the very possibility of experiment in the very use of administrative discretion shows show the possibility of adjustment and to meet urgency, emergency and contingency situations, so also to meet regional and local needs and demands. So these are the fundamental factors which compelled the state to provide the administrative authorities the very power of administrative discretion.